Good afternoon, everyone, and thank you very much for joining us today for this Will Writing webinar, which we are hosting in conjunction with Geldards. My name is Sarah, and I am the Legacy and In-Memory Officer at DVAR, and it is my pleasure to welcome you all to the webinar today. A few housekeeping rules before we begin. As you just saw, the session is being recorded and it will be available on the university YouTube channel, and you will be sent a link in a following up email. The Q&A function will also be available once the presentation begins, should you wish to ask any questions. Huge thanks to all of you who submitted them in advance. We did receive quite a number, so that was really good. And I know Laura, who is presenting today, has tried to answer as many as possible within the presentation, and we'll hopefully have some time at the end of the session to answer any additional queries. So it's my pleasure today to welcome Laura Ikin, who's a Cardiff graduate and an associate solicitor at Geldards. Laura specialises in providing advice in relation to wills, lasting powers of attorney, trusts, tax and estate planning. Thank you, Laura.
Hi, Sarah. Thank you very much. Hello to everyone who's joining. I have some slides that I'll pop up now and we'll start the presentation. So bear with me, here we go. Here we go. As Sarah said, my name's Laura Ikin and I'm an associate solicitor at Geldards. And for those who don't know, Geldards is one of the leading UK law firms. We have offices in Cardiff, the Midlands and London, and we are what's known as a full service firm. So we advise individuals and businesses on a large variety of matters. We're really proud to be a top tier firm, which means a lot of our solicitors are considered experts and leaders in their field. And I specifically specialise in private client matters. So that covers wills, powers of attorney, trust advice and inheritance tax. And so the focus of today's presentation is preparing wills and how that fits in with kind of broader inheritance tax planning. So if we were in person, which we haven't been for a very long time, I would be asking for, show of hands, who here has a will? And I'd expect maybe 50% of the audience to have one. My next question then is usually, when did you last review it? Was it reviewed in the last 5 years? And there is usually a considerable amount of hands that go down at that point. It's really important to have a will, and it's equally as important to keep it under review. The reason it's important to have a will is it gives you peace of mind. It's the only way to ensure that your wishes are carried out in an appropriate and tax efficient way. Without a will, if you were to die, the intestacy rules apply. I'll come to those in a little bit. But it usually would result in a legal headache, which you can read into as lots of solicitor fees, and a necessary tax bill potentially with inheritance tax, and also just result in an outcome that's perhaps not in line with what you would want to happen. And as I said, even if you do have a will, it's really important to keep it under regular review. It's not something that you just do and put it in a cupboard and forget about it for the next 30 years. Looking at some myths around why people think they don't need wills, and I hear this almost daily from clients. I'm married, so my spouse will automatically inherit everything. That's not completely true. It depends on the value of the estate and depends on the family setup, but not everything is guaranteed to go to your spouse or partner. We've been together for years, so we're common law husband and wife. There's no such thing as common law in the eyes of kind of wills and estates planning. You're either married or in a civil partnership, or you're not. And this has implications when one person dies without a will and hasn't provided for the surviving partner. perhaps, I live with my partner, but I'm not really, ready for a serious commitment. If you live with someone, if you're cohabiting, you need a will. If you die without providing for your cohabitee, you could be leaving your estate vulnerable to a claim from the surviving person, and also just making life really difficult for them, because it could be financial, or they could lose the place that you're living in together. So it's really, really important for pretty much everyone to think about doing a will. I mentioned the intestacy rules. So this is the legislation that sets out who receives your estate if you were to die without a will. So I've just summarised these. There's a few different situations and scenarios, so I've summarised these on these slides. So if you're married or in a civil partnership, and you die with descendants, children, grandchildren, there's a restricted entitlement for the spouse. So the surviving spouse gets personal possessions and the first £270,000 of the estate, and then half of whatever remains after that. The children or grandchildren, if that's relevant, they will inherit the rest. So not absolutely everything is guaranteed to go to the surviving spouse in this situation. If you are married or in a civil partnership without children, everything does pass to your spouse, but you need to consider what happens if both of you were to die at the same time or in quick succession. Where does the estate go then? The position of cohabiting partners, the surviving partner has no automatic entitlement to anything, which leaves them, the only option really is for them to bring a claim against the estate, to be able to perhaps continue living in the property or have financial assistance. And having said that, there are some assets that do pass outside of the will. So assets that are owned jointly, they will automatically go to the surviving joint owner. So the most common scenario that would be is either property that's owned as joint tenants or joint bank accounts. Also, most pensions will pass outside of an estate, which means they don't kind of pass through the will. They'll go automatically to whoever the beneficiary should be, provided there's an up-to-date letter of wishes in place. And the same for death and service benefit and a life insurance policy, provided that they've been written into trust and there's an up-to-date letter of wish or expression of wish alongside those. So what's stopping you? What's stopping people making a will? My circumstances can be quite complicated. That's always a reason that people put off making wills. It might be difficult to decide who you want to have benefiting under your will, and especially if things are changing. If you've got young children now, you might think, oh well, things might change in 10 years' time. What do I do then? And that kind of uncertainty definitely kind of stops or adds a bit of a barrier to people making wills. Perhaps you can't decide who you'd have as guardians for your children, or it's quite often something that's on the list and I'll get around to it one day, and then it just keeps getting pushed down the list of things to do. Another reason that I hear very often is people want to make some sort of charitable gift or leave an amount to an organisation, but they can't decide who they want to benefit or how much they want to leave or how they want to do it. And that's quite often another barrier to kind of completing and finalising a will. Your will is the best way to make sure that who you want to benefit from your estate benefits. And it's also an opportunity for you to benefit organisations or charities that are close to your heart. So many people are not aware of that option, that you can leave money to charity or you can leave money to organisations. And research has shown that is quite a person is far more likely to make a gift to charity or an organisation in their will if a solicitor kind of prompts or reminds them. Many people leave gifts to kind of the big charities. So if that's something that you're thinking about, that's fine and quite easy to do. It's also important to take advice or, you know, do your own research or have a think about what's important to you, because I know a lot of clients leave legacies or you know, items to, for example, a local sports club that they were a member of, the small local charity, a church, organisations like the university, Cardiff Uni, and it's important for you to know that you can kind of specify that it's either for a general use and it just goes into kind of the pot, or you can be a bit more specific and you can kind of direct how you would like that legacy to be used. So if, for example, you know of a specific research study, you can inquire with the university about how to benefit that study specifically. Other benefits of leaving a charitable gift is it might save inheritance tax. So if you have a taxable estate, and I'll explain inheritance tax in a little bit, it can save some of the money being taxed. If your estate is taxable, gifts to charities or charitable organisations are exempt from inheritance tax. And if it was something that you were, you know, very passionate about or wanted to leave a bigger sum to charity, if you leave 10% of your estate to a charitable organisation or you know, an organisation that qualifies for relief, you actually get a reduced rate of inheritance tax. It's really worth taking advice about this though, because it's not quite as simple as saying, oh, I give 10% of my estate to charity and then that automatically gets you the relief. It's important to get advice and make sure that that clause is worded appropriately in the will. So moving on to kind of the process of making a will. And I know most people think that the process can be long and drawn out and complicated and difficult to think about. And this is where I come in. Honestly, it can be long and drawn out, it can be complicated, but this is very dependent on your specific circumstances. And to be honest, if your circumstances are complicated, that's even more of a reason to actually do the will and take some advice about it. It does make you think about things that you might find upsetting, but generally, in my experience, most of my clients turn around and say, oh, actually, that wasn't as bad. And I think once you get over the thought of thinking about these things is actually not as bad as perhaps you're anticipating. In terms of the process, it's quite straightforward. What I do, I'll sit down with you and obviously I've either been doing Zoom meetings or phone meetings or in-person meetings if, you know, as we get back to slightly more normal. We'll do a fact find. So it's around, we'll be asking the value of your estate, how it's made up, whether it's property, investments, and also your family situation. Basically, I'm quite nosy and will want to know, you know, the ins and outs of everything. It's understanding your family circumstances, your objectives, and what you want to achieve. I would then, you know, go through some options with you. There's more than, you know, just a straightforward will, the one size fits all. There's a lot of kind of tailoring that can be done with wills. So run through a few options and see what works best for you, so you're making an informed choice. My little picture is that any skeletons in the cupboard, now is the time to tell them, because even if it's something that you might not think is important, for example, if you've got a child from another relationship that, you know, perhaps you're not in contact with, or perhaps even your family aren't really aware of, or there's money that has been promised to you, or you've promised money to someone, that's all the kind of information that I will need to know just to make sure that you're being fully advised, really. So once we've done all that bit, The starting point is usually looking at pretty straightforward wills, which usually is leaving everything to, if you're married, everything to each other, everything to your partner, and then down to your children after both of your days, or if you're single, leaving it to children or leaving it to friends and family, and keeping it quite simple. The benefit of these wills is they're nice and easy to do, they're nice and easy to kind of put into effect whenever the time comes. And if you're married or in a civil partnership, you benefit from what's known as the transferable nil rate band, which is related to inheritance tax, which I'll cover in a moment, and potentially a residence nil rate band, which is an extra amount that you can claim. So from a tax point of view, they are, the most tax efficient way to do things as a married couple, especially. But there are some things to be aware of when you are preparing simple wills. So if you're leaving the entire value of the estate to the survivor of you, you're obviously leaving that amount of money in their name outright, and it's vulnerable to their circumstances. So if the survivor were to remarry or needed care, then they've got this pot of money, and all of that can be taken into account. If they needed to pay for care fees, or if they decided to remarry and wanted to leave everything to their new spouse. Straightforward wills, if you're unmarried, if you're cohabiting, there can be inheritance tax consequences. There are better ways to structure your will if your estate is a decent size. It could result in children inheriting potentially quite large sums at an early age, if the right kind of advice and wording isn't put in the wills. And potentially you're passing an inheritance tax bill down the generations. Just for example, if your estate is, say, £2 million when you die and you pass that to your children, they have got their own estate plus your £2 million. And if they pass that on to their children, so your grandchildren, it's being taxed kind of at every generation. And there are ways in wills that you can kind of make things a bit more tax efficient. So just to cover inheritance tax, I know I've mentioned it. So inheritance tax is charged at 40% on the value of your estate. Everyone has what's known as a nil rate band. So I've mentioned the nil rate band, and that is currently £325,000. So the first £325,000 of your estate, of every individual's estate, is nil rate, is not taxed, basically. Everything above £325,000 is taxed at 40%. There are a few exemptions. So when you're married and you're leaving everything to your spouse, there's generally never any tax to pay at that point. So even if you had £10 million as an estate, if the husband were to die, leaving everything to his wife, there wouldn't be tax at that point. The tax would kick in after the second spouse, after, in that instance, the wife has died. Nil rate bands are transferable. So I mentioned the transferable nil rate band in the previous slide. So what that means in that example is that the £325,000, for example, from that husband will roll over to the wife. So on the second person's death, the wife's death, she would have £650,000 allowance before the 40% tax kicks in. Fairly recently, a few years ago, the government also introduced what's known as the residence nil rate band, which is an extra allowance that attaches to your property and can be claimed, but there's certain criteria that you need to satisfy and be able in order to be able to claim that. But that can bring your entire amount that you're able to leave tax-free as an individual up to a maximum of £500,000. But as I said, there are some rules connected to that. It's not quite as simple as you would hope it would be. I know a lot of people are very familiar with the 7-year rule, and that gets quoted at me all the time. But what it means is that if you make a gift out of your estate to whoever, it can be anyone, that the sum, the amount of that gift, still forms part of your estate for the next 7 years. So if you were to die in those 7 years, it's still counted as your money. Even though the person has it, it's not that it gets taken back from them, but you will be taxed on that full amount, as if that money had never left your account. Just for example, say your estate is worth 500,000, you made a gift of 100,000 to a child. If you were to die within those 7 years from making that gift, for the purposes of calculating the tax on your estate, the value of your estate would be 500,000. If you died 10 years after making the gift, the value of your estate would be 400,000, because that £100,000 gift would have dropped out of your estate. There are some other exempt gifts that you can make, tax exempt gifts. They're kind of smaller customary gifts. So it's, birthday presents, gifts on marriage, smaller amounts can also be kind of taken out of the tax calculation without that 7-year rule applying. So I hope there's a whistle-stop tour of inheritance tax. So focusing back on wills, and these are common kind of will planning dilemmas that I come across. So it's usually, someone's thought about, they want to make a will, they're sitting in front of me, and we've talked about, this is a simple will, this is what you could do. And then these kind of questions will quite often come up. So, I'm worried about a son or daughter-in-law divorcing and then being entitled to half of the inheritance, basically, or concerned about a spouse remarrying and the children being left without anything. Also, it's quite common for family, for children to be working in the family business, or one is more involved than the other, and it's how do you plan for that fairly in the will. Also providing for disabled beneficiaries. So if someone has a child or a grandchild who has a disability and they're especially receiving some supports and benefits, giving them a large lump sum as an inheritance is probably the worst thing that you can do, because you're interfering with their benefits, and also there's a concern about whether they can manage that. And also concerns about children having significant sums at quite a young age. So the answer to all of those concerns is to include a trust in the will. Contrary to kind of perception, it's not just for rich and famous people to have trusts. It's a really valuable tool in estate planning, and they don't have to be particularly complicated. So what is a trust? Essentially, it's a way of making a gift or making assets available to someone, but with strings attached. It allows flexibility and control as to how the person is being provided for. But the assets that are held in trust aren't necessarily vulnerable to the circumstances of that beneficiary. So this is one of the slides that I reliked over and over again, but all of these incredibly rich people have one thing in common, and that is they've spoken out about using trusts or controlling their fortune, I suppose, when it's passing to the next generation. So it's avoiding too much too soon, making sure that their children know the value of work, and doing some planning in the lifetimes. So there are various types of trusts that we consider when we're kind of undertaking will planning and general kind of estate planning. So they're trusts that you can set up in your lifetime, which usually take the form of a discretionary trust, and you can make gifts into it. And it's a very useful tool for doing some inheritance tax planning. That's probably a topic of a whole other webinar, which I'd be very happy to deliver, but I'll focus on the wills for the moment. Will trusts, the main trusts that we would put in a will are life interest trusts, discretionary trusts, trusts for disabled beneficiaries, or nil rate band discretionary trusts. And I wouldn't expect you to come in to me and say, I need a will with a discretionary trust or a life interest trust. it's my job to kind of talk to you and work out and kind of discuss what's most appropriate for your situation. But just to explain the different types of trusts and when you might actually start considering using these. So a life interest trust is really useful. I think they're great. What they do is it gives the surviving, I'm saying surviving spouse because this type of trust in particular, because of the underlying tax treatment, is generally better used when you're married or in a civil partnership. So it gives the surviving spouse the benefit for the rest of his or her lifetime in the asset that's gone into the trust. So for example, if a husband dies and has a life interest trust in the will over his half of the house and perhaps his half of money, if he dies, the wife is able to carry on living in the property, can benefit from any income generated from the money, but the capital value is in the trust and it's protected, so that if the wife, the surviving spouse, needed to go into care, the money that's in the trust can't be taken into account. If the surviving spouse were to remarry, the assets that are in the trust are protected. But after the second spouse has died, so in that instance, after the wife has died, the trust comes to an end and it's distributed then to whoever the beneficiaries are, usually children in that instance. So it's a really good way of making sure your spouse is provided for, but you're kind of ring fencing something to pass down to your children. So as I mentioned, most common situations we see this is either, elderly clients who are more concerned about care, but also younger clients who are concerned about their spouse remarrying, or if they are on a second marriage and have got children from their first marriage, it's a way to make sure that the new spouse can carry on living in the property, but the children from the previous relationship are still guaranteed to have something. Another common type of trust that we use is discretionary trusts. The main feature of this type of trust is that they're very, very flexible. The trustees that you pick manage the trust, and they have discretion as to how and when distributions are made. So the most important thing there is picking people that you trust to make the right decisions. You would generally leave a letter of wishes setting out your wishes and guidance, which generally the trustees would follow, so as to how you would want the money to be used, but it allows them the flexibility to divert from your wishes if necessary. So the types of situations that we would use these is to pass wealth on to next generations in kind of with strings attached, basically, so in a flexible and measured way. So it's benefiting children, grandchildren, without the money actually falling into their hands directly. It gives a lot of flexibility. So if someone comes to me with very complicated wishes, the easiest way to give effect to those is through a discretionary trust rather than trying to make a very complicated will. It saves, though that inheritance tax bill I mentioned before, it saves it passing down the generations. So it can be used as a kind of family trust, which is there to benefit children, grandchildren, and going further down the line. It allows a surviving spouse or partner to benefit from assets which would pass on the first death while keeping the value of those assets out of their estate. So for inheritance tax, it can be quite useful. It's passive. We use these a lot for business owners or agricultural property owners, because it's a good way to ensure that we're claiming the relief, the tax relief that's available to those particular assets. And we use discretionary trusts as well to provide for disabled beneficiaries to stop the money, as mentioned previously, falling directly into their hands. The other type of trust that I mentioned is called a nil rate band discretionary trust. And if any of you have wills that are probably about 20 years old or so, you will probably quite likely have this type of trust in your wills, because it was very commonly used before we were able to transfer that nil rate band to the spouse. So in these, there's a trust that when the first person dies, up to £325,000 goes into that trust, first of all, and then if there's anything left or whatever's left is then goes to whoever, spouse, children, other beneficiaries. We still use these, not as much, but they do have uses, especially when we're looking at being able to claim the residence nil rate band. And as I said, still really useful where business assets are involved to make sure that we're claiming the valuable tax relief that is attached to those. So whenever you have a trust in the will, it's important, as I mentioned, to include a letter of wishes. And we can give you advice as to what to include. They're not legally binding, but it sets out your intentions and wishes. And generally, you'd expect your trustees to follow those as to how the trust fund should be used, unless there is a good reason for them to depart from those wishes. And lastly, that's covered as a whistle-stop tour of wills. But something else I always mention to all my clients whenever I'm talking about wills with them is preparing lasting powers of attorney. These are completely separate documents to wills. So a will takes effect when you die. A lasting power of attorney is a document that you prepare, giving authority to someone to help you either manage your financial affairs or your health and care decisions if you've lost the capacity to do so. So you're still alive, but perhaps you haven't got the ability, the capacity, mental capacity to make those decisions yourself. A lot of people think that if you're married, you don't need one because your spouse is automatically entitled to take over, and they're not. Anything that you have in your sole name, so whether it's a house or savings accounts or bank accounts or investments, if you were to lose capacity, no one else is able to deal with those for you. And it's quite a difficult process. You have to go through the court to have someone appointed to be able to manage those things for you. If you have a power of attorney in place where you name a person or people to be your attorneys, they will be able to make those decisions on your behalf and carry on dealing with property, investment, savings, etc. And even with joint accounts, there is always a risk, and it does happen that if one person, one spouse loses capacity, part of the bank account can be frozen. So the survivor, I'm saying survivors, so the other spouse can't actually access everything if the bank become aware that someone's lost capacity. Doing a power of attorney is quite straightforward, relatively. You are able to do them yourself, but it's usually a good idea to have some legal advice around, making sure they're done properly and all the considerations are, you've taken all the considerations into account, because it's an important document to have. So as much as I urge people to have wills, I always talk about powers of attorney as well, because they are equally important. And again, it gives you that peace of mind that if anything were to happen to you, you've got people that you've nominated who'll be able to take over dealing with your affairs on your behalf. There we go. That concludes my my bit about wills and powers of attorney. So the main message is, don't put it off. Make a will. Even if you start with a very straightforward one and then review it later down the line, is better than nothing. Or review your existing one. That's also very important. Seek advice. We see a lot of people who kind of done their own wills, and it's a minefield. There's lots of pitfalls, so it's always worth paying for the advice at the front rather than paying probably 10 times more at the back end to kind of sort out a mess from a will that hasn't been done properly. And make a lasting power of attorney as well while you're at it. So there we go. And that concludes my bit of the presentation. I should say, I've got my details there. I'm actually on maternity leave at the moment. So I've just stepped in today to do the presentation because it's, I did the last one in January, just before I went on maternity leave. But if you do need to contact, if you want to speak to either of my colleagues, Claire, Binnesley or Esther, they'll be on hand and they'll be your points of contact following this, and I'll be returning to work next year. But don't wait until then. Do it sooner rather than later. There we go.
Oh, perfect. Thank you so much, Laura. It was really, really interesting and informative. I got a lot from that, so I'm sure everybody else did. We have received quite a few questions, which you're kindly going to answer as many of as possible. Yeah. Apologies if we don't get round to answering them all, but Geldards have really kindly offered all registered attendees a free 30-minute phone consultation. So we'll encourage you to take that up, and everything will be included in the post-event email, which will get sent out. So if I just start with some of these. So Laura, as a single parent with no property, what do I need to consider in my will, and what will happen to my assets without a will?
It's still really important to put one in place, mainly because you can name a legal guardian for your child, which, you know, if something were to happen to you and the other parent is still able to look after them, they automatically have the parental responsibility. But it's really important to have a will, because if something's happened to them and there is no one then that, you know, is obvious to look after the child. So if you've named a guardian in the will, the child will be looked after by that person. And it's, you know, you're saying no property, but even if you've got something, it would pass to the child or children, but perhaps you might want, but they would receive at 18. And so you might want to, you know, put an increased age limit so they're not quite as young in inheriting anything. So it'd be 21 or 25 would be the usual.
Perfect, thank you. Is it possible to leave children an annual income in a will rather than a lump sum of money and property?
That would be where a discretionary trust would come in. So you would need, if you wanted to kind of give that level of detail and that kind of provision, a discretionary trust would allow you to do that.
Perfect. Is it important for me to think about my will? I am in my early 20s. It's not me, sadly.
Not me either. It is. Because it's, you know, depending on your circumstances, you'll have something, and even if you have, you know, belongings that you would want to go to someone in particular, even if you don't own a house or anything big, you might have a bank account, you might have some personal items that you would want to go to someone in particular. So it's important that you do have a will for that. And another scenario I've come across quite often is if someone's quite young in their 20s, but their parents are divorced, and perhaps they don't bother or don't have much contact with one parent. So the rules of intestacy would be, if you haven't got descendants, it goes up to your parents. And in that instance, without a will, it would be divided equally between the both parents. And obviously, if that's what you want to happen, then it's not the end of the world if you don't have a will, but depending on your personal circumstances, you know, a will direct who you want to benefit from your estate, basically.
Amazing, thank you. I've got another one here. My mother is not British and does not live in the UK. Will she be taxed if I leave anything to her?
So the inheritance tax in this country is taxed on your assets in this country. It's not a tax on the beneficiary, and it is different. It depends where she lives. There are different countries that have different regimes. But as a starting point, I would, without knowing the detail, the inheritance tax would be charged kind of at source on any assets that are in the UK, and the beneficiary would then just receive their share. But it's something that you probably would need a bit more advice on, depending on which country she lives in.
Amazing. We've got time for a couple more. So if you own assets overseas, in this person's case, the US, are they covered by a UK will?
They can be. The simplest way to manage these things is to have a will in each country that you have assets. But that is something that we can advise on, and we would look at and decide which is the best way to draft it. But usually the simplest way, especially if you have property, if it's a fixed property that's in the US, you would usually need a US will to cover that property. But it's important you take advice to make sure that the wills, if you had one in the US and one in the UK, they need to work together, because what you wouldn't want to happen is for one will to revoke the other, which could be done if it's not, done kind of as a joined up approach.
Great. Is parents gifting their home to their adult children a good way of minimizing inheritance tax?
There's an awful lot I could say about that. From an inheritance, it gets quite complicated. The short answer is probably not, if the parents are going to carry on living there. Because there's a whole there's an issue with giving something away but still retaining the benefit of it. So if the parents gave the house, signed it over to the children, but they carried on living there, it's the HMRC would see straight through that, to be honest. But that's something that if they were doing, they should definitely take advice on, because a lot of people do it for one reason and then discover that because they haven't taken advice, that A, it hasn't fallen out of their estate, B, they'll still be taxed on it, but C, they've also given away ownership of their property that they might rely on. So it's quite a complicated thing to do and advise on.
Okay, so seek more advice then in that.
Yeah. See me.
Yeah. Do executors have to be UK nationals, and similarly for power of attorney?
For wills, no, they don't. There's no kind of restriction really on who can be an executor. Same for an attorney, although from a practical point of view, ideally, especially with an attorney, you would want them to be relatively close by or on hand, because with an attorney, if they need to make decisions for you in an emergency, you don't want someone who's halfway around the world or can't sign something within a short space of time. So it's from a more practical point of view, and the same for an executorship. It doesn't affect it quite so much, but they still need to be able to sign things and deal with paperwork, so there's a bit more going back and forth and posting things.
Okay. What is the cheapest and easiest way to change the executors in my current will?
It depends what you're doing, but rather than rewriting a will, you can do a codicil, which is just a kind of addition to the will, and it would say along the lines of, I revoke clause 1 of my existing will and want my executors to be whoever, and that counts as a change to the will. But again, that has to be done, it still has to be in a formal document, it still has to be signed and witnessed and dated for it to be valid.
Okay, great. We've just got a couple more now, got a bit of time. So can a spouse name the other spouse as their power of attorney, or is that best not done? Yeah,
no, definitely, it makes sense, really. This is a common way to do it.
Okay, amazing. And I think I've got time for just one more. Do life interest trusts come under the 7-year rule?
They don't, because they get treated in a different way, but you're not necessarily making a gift of a property or an asset, so they don't necessarily get caught by the 7-year rule. And I'm assuming talking in relation to a will rather than in a lifetime.
Yeah.
No, it'll require probably a bit more detailed having a chat, but the easy answer is no, they don't.
Okay. Amazing. Oh, thank you so much, Laura, and to Geldards for taking the time to present today, and to all of you for joining us. I hope you enjoyed it. Like I said earlier, I got a lot from that. So at Cardiff University, we are incredibly lucky to have received some really generous gifts in wills. And I would be more than happy to speak to you firsthand if you are considering leaving a gift in your will to a charity. This type of giving, and I can't really stress this enough when I speak to people, honestly makes just the most remarkable difference. It's enabled, the gifts that we've already received have enabled us to do truly extraordinary things, such as funding life-saving research, funding life-saving equipment. Several of our researchers are currently funded by legacies, and we've also helped so many students facing hardship. There are so many options. And as a charity, we would love for you to consider us if you are thinking of including a gift in your will. I'm really nice to chat to, so feel free to pop me an email or drop me a line. I'd be more than happy to set up a meeting, and would love to be able to talk to you about your considerations. Before you leave, I also wanted to take this opportunity to let you know that we have a really fantastic webinar coming up on Tuesday, October 26th, one you won't want to miss. It's a new hope for cancer treatment, and we're looking at the surgical technique for delivering targeted chemotherapy. So it's going to be really, really, really interesting, and one you should definitely sign up for. So keep an eye out for that in your post-event email, which will also contain all of the details about the free 30-minute consultation with Geldards as well. So all that remains is for me to say thank you so much for joining us today. Thank you again to Laura, and have a lovely rest of your afternoon. Thank you.